Hey guys, attorney Jerry Parisi here, and today I'm going to answer the question, what is a debt buyer? And also, why does it matter? So really easy, a debt buyer is a company that purchases defaulted debts on the open market from original creditors, usually for pennies on the dollar, and then they attempt to collect on that debt, usually by suing the debtor in small claims court. Here in Georgia, it's called magistrate court. So I mentioned original creditor. What is an original creditor? And how's it different from a debt buyer? The original creditor is the company or the person that you originally were indebted to. So in the credit card context, that's American Express, Citibank, Capital One, whoever the credit card company was that issued you the card, that's the original creditor. In the medical debt context, it's the hospital that you went to, the provider, whoever you incurred the debt with. Whereas the debt buyer is the company that purchased that debt from that original creditor. Why does it matter? What's the difference between it? Who cares? Usually when you're looking at these videos, it's because you've been sued by a debt buyer or an original creditor and you want to determine which one. So really when the lawsuit is filed, that's when it matters. That's why you want to figure out which one you're dealing with and how to approach it. And I think it matters for two reasons. First, the Fair Debt Collection Practices Act is a very strong law that protects consumers from debt collectors, and it only applies to debt collectors. So it does not apply to original creditors. If you have a debt buyer lawsuit, it probably applies to them, and they potentially violated the FDCPA, the Fair Debt Collection Practices Act. So I think that's one way that it really matters. And the second way is if you're facing a debt buyer lawsuit or an original creditor lawsuit, your defenses are going to be different. Like how you put up a defense, what you want to say, and how you approach the case is going to be totally different depending on which one you're dealing with. So an original creditor usually has an easy time proving their case in court, right? You took out the debt with them. They've got all the paperwork. They usually keep pretty good records so they can prove it. But a debt buyer has additional things they need to prove. And here in Georgia, what do they have to prove to show, to prove their case in court? They've got to show two things basically, but it's a little bit more nuanced. Two things: they've got to show that you owe the debt in the amount that they're seeking, and two, that they own the debt, that they validly and legally purchase it. And they're the actual owners. Because if they can't prove that they own it, they lack standing to sue you, and you can get the case dismissed that way. So how do you determine if you're facing a debt buyer or an original creditor? Usually if it's Citibank, American Express, if you recognize the company that's suing you, that's usually an original creditor. If you don't recognize them, do a little bit of research, see who they are, possibly a debt buyer. Another way is look at the top at the lawsuit or the statement of claim, see who the named plaintiff is. If the named plaintiff is a company you don't recognize, like I said, could be a debt buyer. So Google them, see who it is. Another thing they like to do is say, here's a common name of a debt buyer, it's Midland Funding. And they'll say Midland Funding as assignee of Capital One Bank, or whatever the bank was, whatever the credit card company was. And that language, as assignee, makes it look like, oh yeah, I had a Capital One credit card. This is, the company that gets to sue me. No. The debt buyer is trying to trick you. They're trying to trick the court. I don't think they should be allowed to do this, but they put that language in there, and they've got to prove that they're the assignee of whatever, Capital One Bank or Bank of America, Chase. They've got to prove it. They can't just say it in the style of the case where they're supposed to put their name as the plaintiff. They're the plaintiff. They should identify themselves as Midland Funding, whoever they are, not as assignee of blah, 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 whoever bank. So I think that's a little trick they like to pull, but do your research and see who they are if they're a debt buyer. And if you've got a debt buyer case, your defenses, like I said, they're going to be different. You're going to challenge their standing. You're going to challenge the fact that they're the assignee of whatever bank they're claiming to be the assignee of. Because in a lot of these cases, it gets hard for them to prove because they bought these debts for pennies on the dollar. They bought a ton of accounts at the same time. And a lot of times these accounts, these old debts are bought and sold on the market several times before a lawsuit is brought. So it could be 3 times, 5 times, whatever. And they've got to prove at every sale, at every transfer, there was a valid assignment, and not just a valid assignment, but of your debts. They got to prove that your debt was included in that transfer from each debt buyer to each new debt buyer. And it gets tricky, things get lost. If they can't prove that there's a valid, total, complete chain of assignment going all the way back to the original creditor, their case crumbles. So you want to poke holes in that. You want to have an attorney look at that and poke holes and see what they cannot prove to break their case. So what should you do if you've been sued by one of these companies? I mean, the first thing you should do is do your research, see who the company is, and then call an attorney. Get a free consultation with an attorney. See if it makes sense for you to hire the attorney if you can afford it. Call legal aid if you cannot afford it. And then definitely make sure you file an answer within 30 days of being served with a lawsuit. Can't stress that enough. Whether your attorney does it for you or whether you do it on your own, file an answer within 30 days or you'll be in default. And you don't want to be in default when you've got a debt buyer lawsuit. You want to put up a fight, at least put up a defense, and see where it goes from there. Either settle it or win it outright, or best case scenario is you've got a counterclaim and you can sue them and win your attorney's fees and some money on top. The FDCPA allows for $1,000 in statutory damages. There are some other consumer protection laws that may apply. Here in Georgia, the Georgia Fair Business Practices Act is a strong consumer law. So best thing you can do is hire an attorney who knows what they're doing and knows what claims, what counterclaims you may be entitled to bring. If you have any questions, you can give me a call at 404-594-5130 or find my website, parisifirm.com.